let's now take you to the court where Mr Justice Murray has started to deliver his sentence at Chelmsford Crown Court.
Gavin Plumb, you are here today to be sentenced following your conviction on the 4th of July 2024 by a jury at this court of the following offences: soliciting murder, encouraging or assisting the offence of kidnapping, and encouraging or assisting the offence of rape. All three of your offences were committed against Holly Willoughby. With considerable courage, Ms. Willoughby has waived her statutory right to anonymity in relation to the third offence, so that details of all of your offending can be reported. Holly Willoughby is a well-known and well-loved public figure. There is, as a result, a heightened public interest in this case. Like everybody else, however, she is entitled to respect for her private and family life. As Ms. Morgan KC, leading counsel for the Crown, said earlier today, Ms. Willoughby has cooperated fully with the prosecution in this case and provided a victim personal statement. Its contents, however, are private. It has been shown only to those who need to see it, including the prosecution, you and your legal team, and me, as the judge who presided over your trial and who will be sentencing you. Ms. Willoughby does not wish for her statement to be read out in court or otherwise made public. That is her right, and we have respected that wish. The purpose of a victim personal statement is so that the court is informed of the impact that the relevant offending has had on that victim. I have carefully read Ms. Willoughby's statement. Out of respect for her wish for its contents to remain private, I simply note that I am satisfied that these offences have had life-changing consequences for her, both privately and professionally. In assessing the impact of your offending, I bear in mind the broader effect of this type of offending on women generally, who should not be made to feel unsafe as they go about their daily lives. On Tuesday, the 3rd of October of last year, you were online participating in a public group chat on the Kik messaging app. Although the word chat suggests something benign, this particular chat group was called Abduct Lovers and involved people with an interest in abduction, rape, torture, human trafficking, and murder of former partners, ex-colleagues, neighbours, and others, including celebrities. The group had 100 members. The profile picture for the group was a young, blonde woman with a distressed expression, a male hand covering her mouth. Your personal profile picture on the Kik app was an image of Holly Willoughby. Your username was BigBear341987. During your evidence, you admitted that you had been an active member of the Abduct Lovers group chat for some time, although you could not or would not say how long. On 3rd of October 2023, you posted 4 pictures of Ms. Willoughby to the group with the caption, quote, "the one in the public eye I want," close quote. Another user in the group with the username David Nelson responded, "nice." You then posted the message saying that you had a lot of information about her. You knew when she does and does not have security, you knew that she did not have CCTV at home, and you knew when she got up in the morning. David Nelson sent you a private message, and you then exchanged with him over 300 private messages on the Kik app during the next 30 hours or so. You discovered that David Nelson was based in the USA and that he'd never heard of Holly Willoughby. He asked you why you had posted about her in an abduction group. And you said, "Why do you think?" You told David Nelson that you had identified Ms. Willoughby's home address, and you sent him an image of it from Google Maps. You made it clear that you were planning a nighttime home invasion of that address, and that you'd been studying access points and other practicalities. David Nelson asked if you were looking for help, and you made it clear that you would welcome it. You had been discussing your plan to kidnap and rape Ms. Willoughby with others, and they had got cold feet. You said you would carry out your plan on your own if you had to. During your exchanges with David Nelson, you talked about possible dates for the home invasion, flights from New York to London, details of Ms. Willoughby's car, and how you plan to use it for the plan, and the road route from Ms. Willoughby's home to yours. You even fixed on some dates for the commission of the intended offences within the next few days after these conversations with David Nelson. Neither of you had a valid driving license, but of course that would not have stopped you driving. You had been taking driving lessons. You also discussed trying to recruit a third person to drive the car. The plan was to take her to your flat initially and then to an abandoned building. With David Nelson, you talked about the use of chloroform to incapacitate Ms. Willoughby and her husband, and you sent David Nelson photos of the bottles you had bought online. You sent David Nelson a video showing your restraint kit, which included handcuffs, ankle restraints, gags, an eye mask, ropes, and metal cable ties, as well as other BDSM equipment, including a whip. You had bought the ropes in February 2022, and you'd bought the 4 packages of metal cable ties in April 2022. You told David Nelson that you planned to use knives in the attack, including kitchen knives and a utility folding knife that you bought on the 1st of August 2023. David Nelson said that he lived in New York, and he would only spend the money to travel to London if, quote, this was a serious thing, close quote. You said, quote, definitely serious for me anyway, close quote. You made a number of other statements to the same effect. I have no doubt that this was all considerably more than a fantasy to you. You told David Nelson that you'd been planning this for about 2.5 years. Your plan was hopelessly unrealistic for a number of reasons, including your poor physical health, but you clearly thought it was feasible. Although you talked about carrying out the plan on your own, I am sure that this was simply bravado. You always intended to carry out your plan to kidnap, rape, and kill Ms. Willoughby, but only if you could find the right man or men, the right, quote, crew, close quote, as you sometimes called it, to help you do it. This was one of the principal purposes of your participation in the Abduct Lovers Kick group and other online chat groups with similar themes. After years of frustration, talking about your plan online with a number of others, you thought that you had finally found in David Nelson someone who would really help you. At one point you said, it's actually happening. You exchanged live videos with David Nelson, during each of which you said the date, 3rd October 2024, and the code word, Holly, to prove to each other that you were real. Unfortunately for you, David Nelson was an undercover police officer based in Minnesota. David Nelson is not his real name, but I will continue to use it in these sentencing remarks. His role is to carry out online investigations using various fake identities, looking for instances of human trafficking, murder for hire, kidnapping, rape, drugs conspiracies, and other serious crimes. David Nelson was one of his fake online identities, which he'd been using for about 3 years. I permitted him to give his evidence during the trial anonymously to protect his personal safety and that of his family. as well as to protect the public interest by preserving his ability to continue his important undercover work. In evidence, David Nelson said that what you had posted in the public chat of the Abduct Lovers group went beyond what was typically posted, and he was immediately concerned that you posed an imminent threat to the woman you had named. He asked you various questions to draw out details of your plans and to assess whether you were just fantasizing or posed a real danger. The vast majority of online messages that he monitored during his professional work, he told us, did not go beyond dark, unpleasant, twisted fantasy. His rapid professional assessment, however, in relation to you, was that your messages were of a different order and revealed a real danger. During the trial, the jury had all of your private kick messages with David Nelson in a document that during the trial was called the sequence of events, setting out the messages chronologically, line by line. It is clear early on during your exchanges with David Nelson that your plan was to kidnap, rape, and otherwise sexually abuse Ms. Willoughby. When David Nelson asked you whether she was, quote, going to be returned, close quote, you said no. Later in the exchange, when David Nelson asked what would happen when you were, quote, done, close quote, you said, quote, slit her throat, clean her out, and dispose of her, close quote. Later still in the exchange, you made it clear that when you were finished, the plan was to slit her throat, wash her in bleach, and dump her body in a lake. You introduced the idea of murdering Ms. Willoughby into your exchanges with David Nelson, and you clearly sought to persuade him to participate in this part of the plan, whether it was to be David Nelson who actually slit her throat, or you doing so with his participation, assistance, or encouragement. That is the basis of your conviction for soliciting murder. Another deeply unpleasant aspect of your exchanges with David Nelson was your saying that you had another potential victim to, quote, practice, close quote, on, namely a neighbour of yours. You sent images.
We're just going to cut away from the court for a short period of time due to the nature of the evidence that's being heard. You're hearing Mr Justice Murray carrying out the sentencing for Gavin Plumb, who was found guilty of plotting to kidnap, rape and murder Holly Willoughby last week. The judge said he is, in terms of what he has heard from Holly Willoughby, who has given a victim impact statement, he said, I simply note that I'm satisfied these offences have had a life-changing effect on her. And he said he has also considered the broader effect that they have had on women widely who should not be afraid to go about their daily lives. Let's return to Chelmsford Crown Court.
You boasted to David Nelson about your prior convictions for attempting to kidnap 2 young women in August 2006 and for false imprisonment of 2 other young women in December 2008. I will come back to those prior offences in a moment. Your interest in Ms. Willoughby went back much further than the 2 dates in early October when you were chatting on the Kick app with David Nelson. You told David Nelson that you'd been planning to abduct and rape Ms. Willoughby for about 2.5 years. In a WhatsApp message to a person we knew during the trial as Mark, M-A-R-C, who asked you on 28th of December 2021 how long you had wanted to rape Ms. Willoughby, you replied, quote, about 3 years, but people claim to want to, then back out, close quote. So your criminal interest in Ms. Willoughby dated from at least 2018. The police found that you had downloaded millions of images. They were only able to view about 10% of the total. They found thousands upon thousands of images of Ms. Willoughby, including not only genuine images of her, but also deep fake porn images. In other words, images that had been digitally manipulated to impose Ms. Willoughby's face on the body of another woman in a pornographic situation. At the trial, the jury saw over 900 WhatsApp messages that you exchanged with Mark between 28th December 2021 and 7th of June 2023. The messages included both text messages and voice notes. Many of the voice notes were played for the jury. It appeared from the messages that Mark was Irish, lived in Ireland, and had previously been convicted and sentenced for stalking a woman. During your exchanges with Mark, you exchanged numerous images of Ms. Willoughby, mostly genuine, but at least one deepfake porn image, as well as images of other women, including porn images showing women tied up and or wearing gags. You also discussed plans to kidnap, rape, and otherwise physically abuse Ms. Willoughby with Mark. Many of the messages about what you planned to do to Ms. Willoughby were so horrifying, shocking, and graphic in detail that they were not read out in open court. The jury, however, read every single message during the trial. Accredited members of the press were also given access to the full set of messages during the trial. During your exchanges, you boasted to Mark about your own convictions for your offences in 2006 and 2008. As when you boasted to David Nelson, I'm sure that you did this in order to make clear to Mark that you were not a fantasist, but someone who had a proven record of sexually motivated violence against women, and that you intended to carry out the offences that you were discussing with him against Ms. Willoughby. Quite a bit of your chat with Mark was devoted to the pragmatic details of planning the abduction and rape of Ms. Willoughby, including reference to others with whom you were discussing your plans and whom you hoped to recruit to participate in it. As DC Belsham told us during the trial, the police were not able to recover the full set of all of your exchanges with any others with whom you may have been discussing these matters. But you make numerous statements during the nearly 18 months of your WhatsApp exchanges with Mark that indicate the seriousness of your intent and your disappointment that others whom you had tried to recruit got cold feet. On the 29th of December 2021, for example, Mark asked you, quote, "What's the closest you got to Holly?" Close quote. You responded, quote, "Planning to track her movements. The last guy pulled out, then told me it's just fantasy, despite finding out all the information we did on her." Close quote. During the trial, there was evidence of your chats about Ms. Willoughby with others on the Kick app, including persons with the user names, quote, "Dave Tomcat," close quote, "Josh Green 977, close quote, quote, "Carisbrook 1, close quote, and, quote, "Dubliner 1975, close quote. These four were saved in your phone's contacts as Dave Tom, Josh Green, Alfie Noakes, and Mark B, respectively. During your exchanges with Mark, you referred to conversations with others about your plan to abduct Miss Willoughby, including persons referred to as Ryan, Rob, R, which may be a reference to Ryan, Rob, or some third person, Tab 00K and K, and, quote, "the other guy," close quote. On 17 February 2022, you referred to having 5 persons in total, quote, "on board," close quote, to carry out your home invasion plan, including Mark and you. By 28 March 2022, you were back down to 3 persons, Mark, Ryan, and you, and you said Ryan, quote, "was getting cold feet," close quote. In June 2022, you were discussing getting a new crew together. Throughout the nearly 18 months of your WhatsApp exchanges with Mark, you refer to your discussions with others about your plan, with you often expressing disappointment that someone you had thought was seriously interested had got, quote, "cold feet," or indeed had blocked you on the relevant app. You discussed with Mark on WhatsApp many of the same topics and details of your home invasion and abduction plan that you later discussed with David Nelson. These included Ms. Willoughby's home address and how best to access it, restraint of Ms. Willoughby and her husband using ropes, cable ties, and other items from your restraint kit, and the use of chloroform to incapacitate them. It was during this period that you purchased online the rope, the metal cable ties, the utility folding knife, and the 2 bottles of chloroform. On the 6th of May 2023, you sent Mark the same video showing your restraint kit that you later sent to David Nelson. On the 14th of May 2023, you sent 2 photos to Mark of various realistic-looking imitation firearms available for purchase online, although there's no evidence that you actually did purchase them. You carried out various web searches on chloroform that were primarily concerned with the legality of purchasing or owning it and its inability to incapacitate a person. The police subsequently discovered, upon analysis of the contents of the bottles, which were unopened when the police seized them, that they did not, in fact, contain any detectable level of chloroform, but only ethanol and water. You, however, clearly believed that you had purchased chloroform when you bought them online from a homeopathic pharmacy. Your claim in your evidence that you had bought the chloroform to clean a stubborn stain on your living room carpet was a particularly clumsy and obvious lie. At various times during your WhatsApp exchange with Mark, you discussed looking for an abandoned property outside of London where you could hold Ms. Willoughby. On one occasion in June 2022, you forwarded to Mark a photograph that had been sent to you of a room on an abandoned stud farm that you thought might be suitable for this purpose. One particularly deeply unpleasant aspect of your exchanges with Mark, which did not appear in your exchanges with David Nelson, was your discussion of restraining Ms. Willoughby's children and using her fear for their safety as leverage with which to control her. Your exchanges with Mark, together with your exchanges with David Nelson and related evidence, form the factual basis for your offences of encouraging or assisting the commission of the offences of kidnap and rape, with the intention that these offences be committed. You have previously been convicted of sexually motivated offences against women, as I've already mentioned, involving the threat of violence and or unlawful restraint. On the 14th of August 2006, when you were 19 years old, you approached a young woman on the Stansted Express and gave her a note saying that you had a gun and that she was to get off at the next stop with you, or you would shoot her, yourself, and everyone else. Other passengers noticed her distress, and you got off the train at Stansted Mount Fitchett. 2 days later, you approached another young woman on the Stansted Express and gave her a note saying that you were a police officer and that she was to get off with you at the next stop for a, quote, quick chat, close quote. She refused, and you got off at the next stop and sat on the platform where the police found you later that day and arrested you. When arrested, you were found to have on you an imitation firearm and 3 rope ligatures. On the 16th of March 2007, for these offences of attempted kidnapping, to which you had pleaded guilty, you were sentenced to a term of imprisonment of 12 months, suspended for 2 years with supervision and activity requirements. On the 11th of December 2008, when you were 21, while you were working at Woolworths in Harlow, you approached 2 16-year-old girls who were also working there with a box cutter or Stanley knife type instrument, and you threatened them, telling them to get to the back of the stockroom. After failing to untangle a piece of rope that you had intended to use, you took out some tape and began to bind the hands of one of the girls behind her back. The other girl escaped, and the alarm was raised. The police attended, and you were arrested. On the 15th of June 2009, for these offences of false imprisonment, to which you had pleaded guilty, you were sentenced to a term of imprisonment of 32 months. There is no offence-specific sentencing council guideline in relation to any of these offences. I have had regard to the guidelines on overarching principles and totality. In relation to the offence of soliciting murder, I have considered the decisions of the Court of Appeal referred to in the sentencing note provided by the prosecution and by the defence. I bear in mind, however, the facts of those cases are quite different to this one. I have had some limited regard to the guideline on attempted murder. However, I bear in mind the decision of the Court of Appeal in the Crown and Franks, which delineates the clear differences between those two offences. In relation to the offence of encouraging or assisting the offence of kidnap, I bear in mind, in relation to the underlying offence of kidnapping, the principles summarised by the Court of Appeal in the Crown and Saqib, S-A-Q-I-B. In relation to the offence of encouraging or assisting the offence of rape, I've had regard to the Sentencing Council guideline on rape. Given that all three of your offences were part of a single plan to kidnap, rape and murder Holly Willoughby, the correct approach in this case is to pass concurrent sentences that reflect the totality of your offending. Although not all of the detail of the plan discussed by you with Mark over the course of 18 months was discussed with David Nelson during the 30 hours or so of your kick message exchanges with him, the plan that you revealed to David Nelson was, in its fundamentals, the plan discussed with Mark. Accordingly, in assessing culpability and harm of your offence of soliciting murder, I've had regard to the evidence about the plan that emerges from the WhatsApp exchanges between you and Mark. The key point in this regard is that the plan to murder Ms. Willoughby was the end point of a plan developed over a considerable time to kidnap and falsely imprison her for the principal purpose of raping and otherwise sexually abusing her over a sustained period of time in ways that, judging by your discussions with Mark, would have been particularly sadistic, brutal and degrading. The plan was, in short, the context in which you solicited David Nelson to murder or assist you in murdering Ms. Willoughby. I have no hesitation in concluding that each of your three offences is one of very high culpability, having in regard in particular to the sexual motivation of your offending and your intention to inflict extreme and gratuitous degradation on your victim. The intended harm of each offence was, in each case, of the highest category for the relevant offence. There is no doubt that if you had genuinely found one or more accomplices who were seriously interested and had been willing to join you in carrying your plan through, then you would have put this plan into action. Turning to the aggravating factors in this case, and taking care to avoid double counting, I find that your offences are aggravated by the following factors. A, your prior convictions for violent, sexually motivated offences against women by way of attempted kidnap and false imprisonment. B, the lengthy and detailed planning of your intended offences against Ms. Willoughby over the course of nearly 2 years. C, the purchase of items to be used in the commission of the offences, including your restraint kit, a knife, and chloroform. D, the research you conducted into the personal life of Ms. Willoughby. E, the fact that you sought to encourage more than one person to commit these offences with you. F, the fact that you intended to commit these offences in Ms. Willoughby's home and to involve her husband and children and to harm them. And G, that your plan to carry one or more knives to the scene to be used in the attack and to be used to murder Ms. Willoughby. I do find that there is some mitigation in this case. A, your plan was unlikely to succeed, given, number one, your physical limitations, in particular your gross obesity and the accompanying physical health aspects of that. Secondly, your lack of a car and a driving license, although I note that you were taking driving lessons, and having no driving license would not have prevented you from driving Ms. Willoughby's car. And thirdly, the difficulty you would have had in practice of bringing Ms. Willoughby to your own flat undetected, and your lack of any alternative premises in which to keep her, although you had researched various possibilities. I note, however, in relation to this point, namely the unlikeliness of your offences succeeding, your intended offences succeeding, that the essence of your offences was the soliciting of murder by another and the encouraging or assisting of another to kidnap and rape. That is the essence of those offences. It is fortunate that you did not succeed in finding one or more others who might have been considerably more physically able, and perhaps more able in other ways, than you were at the time of the offending. You were born on the 25th of February 1987. You are now 37 years old. I have borne in mind your background of physical ill health, including increasing struggles with obesity to the point of gross obesity from the age of 13, as well as the social difficulties, physical health issues and mental health issues that have accompanied that. I have borne in mind that all of your research regarding Ms. Willoughby was done online and that you never went to her house or stalked her in person, although it is clear that you considered and discussed doing so. All three of your offences fall within Schedule 19 to the Sentencing Act 2020. Given all that I know about you, having presided over your trial, I do not consider it necessary to have had a pre-sentence report for purposes of assessing whether you are a dangerous offender. I am required first to consider whether I must impose a sentence of imprisonment for life, given the seriousness of each of these offences. Although the offences of which you have been convicted concern only one woman, it is clear from the evidence, including your prior convictions, that you pose a significant risk to women generally of serious harm occasioned by the commission of sexually motivated acts of threatened and actual violence. I find, in other words, that you are dangerous. Having regard to the seriousness of each of your offences individually and together, as well as everything else I know about you, including the facts of your prior convictions for similarly sexually motivated violent offending against women, I conclude that I must impose on you a sentence of imprisonment for life. It will, in fact, be 3 concurrent sentences of imprisonment for life. This is not a case of such extreme seriousness that it is necessary to impose a whole life order. In other words, an order under which there is no possibility of you being released. Accordingly, I must determine the minimum term that you must serve for each of these offences. If I had been sentencing you to a determinate sentence, taking account of the numerous aggravating and limited mitigating factors in this case, but avoiding double counting, after a trial I would have sentenced you to concurrent sentences of 24 years imprisonment for each offence. Because you would have served up to 2/3 of that sentence in custody, I fixed the minimum term you will serve at 2/3 of 24 years, that is, 16 years. Finally, I reduce that minimum term of 16 years by the number of days which you've spent on remand in custody, 280 days. This means that the minimum term which you will serve before the parole board may consider your possible release is one of 15 years and 85 days. It is important that you and everyone concerned with this case should understand what this means. The minimum term is not a fixed term after which you will automatically be released. You must serve every single day of that minimum term. And it must be served before the parole board can undertake their first review of the case. At that stage, they will review the risk that you then present and will consider whether you can properly be released from custody subject to license at that stage, and if so, on what terms. If and when you are released, you will be subject to license, and this will remain the case for the rest of your life. If for any reason your license is revoked, you will be recalled to prison to continue to serve your life sentence in custody, and it may well be that you will never be released again. It follows that unless and until the parole board consider that your release is appropriate, you will remain in custody, and as I've just said, possibly for the rest of your life. In order to protect Ms. Willoughby from further harassment, you will be subject to a restraining order prohibiting you from contacting or attempting to contact her directly or indirectly, including via social media, email, telephone, post, or text message, and prohibiting you from entering an exclusion zone shown in a map attached to the restraining order. The restraining order also prohibits you from attending as an audience member or for any other purpose any television show or other public event that Ms. Willoughby is presenting or appearing in or at. This order will last indefinitely. Given that I will be imposing a life sentence for each of your offences, it is not necessary for me to make a sexual harm prevention order against you, as the risk that you pose in that regard will be adequately managed through the management of your life sentences. I certify that you've been convicted of a sexual offence, so that you must, for the rest of your life, keep the police informed at all times of your personal particulars, the address at which you are living, and any alteration in the name you are using. You will be given full details of these requirements on a form at the end of this hearing. The offences of which you have been convicted are ones that will make you subject to barring from working with vulnerable adults. You will be told of the restrictions under the Safeguarding Vulnerable Groups Act 2006 by the Disclosure and Barring Service. The statutory surcharge provisions apply to this sentence. Gavin Plumb, please stand up. Over a number of years, you pursued an unhealthy sexual obsession with Holly Willoughby that led you ultimately to plan over that period to kidnap, to rape, and to murder her. You researched her home address, her security arrangements, her daily routine, her route to work, her family. You assembled a restraint kit. You bought what you believed to be chloroform to incapacitate her and her husband. You intended to harm her husband and her children as part of your plan. You attempted to recruit several people to help you. You discussed with Mark and with David Nelson, and no doubt others, in hideous and revolting detail, the prolonged sexual violence that you intended to inflict on Ms. Willoughby once you abducted her and had her under your control. You had previously been convicted of terrifying offences involving the threat of sexual violence against 4 different young women. I found you to be dangerous. You solicited David Nelson to murder Ms. Willoughby or to assist you in murdering her. You encouraged Mark and David Nelson to participate in your plan to kidnap and rape Ms. Willoughby. The jury saw through the various lies that you told at the trial and convicted you of these offences, for which I now sentence you as follows. For the offence of soliciting murder, I sentence you to life imprisonment with a minimum term of 15 years and 85 days. For the offence of encouraging or assisting the commission of the offence of kidnapping, I sentence you to life imprisonment with a minimum term to serve of 15 years and 85 days. And for the offence of encouraging or assisting the commission of the offence of rape, I sentence you to life imprisonment with a minimum term to serve of 15 years and 85 days. You may go down.
Well, there you have it, the sentencing read out by Mr. Justice Edward Murray for Gavin Plumb for a plot to kidnap, rape and murder the television presenter Holly Willoughby. Life imprisonment with a minimum term of 15 years. The judge saying that some of the details that they heard during this trial were horrifying, shocking and graphic. The jury read every single message that was sent, which revealed a plot and a plan hatched by Plumb to kidnap the television presenter. Let's bring in our crime correspondent Martin Brunt, who is following this case for us now. Martin, so Plumb jailed for life with a minimum term of 15 years.
Yes, it could have been a heavier sentence. The judge said he didn't feel that it was appropriate to give him a whole life sentence, and he could have, having given him a life sentence, he could have extended, given him a bigger minimum term, but nonetheless, that's a pretty heavy sentence, 3 life sentences, and he will serve a minimum of almost 16 years before he even gets the chance to ask for parole, and the judge underlining to him, as judges do in these circumstances, that there's no automatic release after the serving of that minimum term. He will still have to persuade the parole board that he's safe to be released, and on that point the judge said that he said it was clear from the evidence that you pose a significant risk to women generally. You are dangerous, the judge said, in his view. So that rather indicates that even at the end of that minimum term of 16 years, Gavin Plumb, as things stand at the moment, will probably find it difficult to get over that hurdle of persuading the parole board at that stage that he is safe to be released. I think the judge said at one point it may well be that you spend the rest of your life in prison. And towards the end of those rather long sentencing remarks, he said, as the defence had, well, prosecution and defence had said, that this was a plan. The prosecution adamant that it was a plan that was going to be turned into reality, the defence saying it was nothing more than fantasy. Well, the judge's view towards the end of those remarks was that this was, in essence, a crime of soliciting and encouraging others. He said, but it's fortunate that you didn't find somebody more able than you to carry out that plan. And he talked about how his excessive weight, the fact that he didn't have a car, couldn't drive, wasn't able to clamber over the walls around the fences around Holly Willoughby's house. All of that, the judge said, made this plan hopelessly unrealistic. The point of the prosecution and the conviction was that his intention to carry it out was what mattered, and as the judge said, the jury saw through your lies. So in the next couple of hours, Gavin Plumb will be taken off to start that rather long prison sentence.
The judges summing up some of the detail that had been heard in court, horrific, disturbing detail of the plot that was hatched by Plumb, his conversations with people online, including that undercover police officer. And what was remarkable in some of the judges summing up there in his sentencing remarks was his references to some of Plumb's other attempts to try and abduct and kidnap women, including those ones near Stansted when he tried to abduct people from a train.
Yes, at the start of the trial, the prosecutor was allowed to tell the jurors about his previous convictions. Now, that's not become common, but we do see this from time to time. It's a new convention, relatively new, where if somebody has a previous record of very similar crimes, then prosecution has to argue this with the judge, but is sometimes allowed to let jurors know. And I imagine that probably made a big impact on the jurors, because they took some time to come to their decision, over a day after a very short trial. But I think in reaching unanimous verdicts, as they did on all three charges, I think the fact that Gavin Plumb had done something similar before probably added a lot of weight to that decision. We don't know quite, of course, how in any way how they reached their decision, but yes, there were previous crimes from the age of 19, so 17 years ago, 17 or 18 years ago, 2 attempts to kidnap, abduct a stewardess on the train to Stansted Airport. So the first one, he sits down in front of a stewardess. She's wearing a Ryanair uniform, gives her a note and says, I've got a gun. If you don't get off with me at the next station, I'm going to shoot you, and I'm going to shoot everybody, and then I'm going to shoot myself. Now, she burst into tears and he ran off. But he tried something very similar 2 days later, and in the end ran off himself again and was arrested, given, perhaps a sign of the times, only a suspended sentence. 2 years after that, he tied up a young girl he was working with as a security guard at Woolworths in Harlow, his hometown, and did end up, for false imprisonment, that was the crime at the time, getting a prison sentence that he had to serve, 32 months. So the judge, again, emphasising in his remarks just before sentencing that he was a man. For all he said about the Holly Willoughby plot being pure fantasy, no intention to carry it out. He was a man with a history of violence, sexually motivated violence towards other women.
Indeed. Martin Brunner, our crime correspondent, for now, thank you for that. Well, let's just listen back now to the sentencing remarks of Mr. Justice Edward Murray as he sentenced Gavin Plumb to life in prison with a minimum term of 15 years.
After a trial, I would have sentenced you to concurrent sentences of 24 years imprisonment for each offence. Because you would have served up to 2/3 of that sentence in custody, I fixed the minimum term you will serve at 2/3 of 24 years, that is, 16 years. Finally, I reduce that minimum term of 16 years by the number of days which you've spent on remand in custody, 280 days. This means that the minimum term which you will serve before the parole board may consider your possible release is one of 15 years and 85 days.
During this morning's sentencing, Alison Morgan, Casey, said that Holly Willoughby wanted her personal victim statement to be kept private, but said it set out the catastrophic impact of these offences. Well, Ms Morgan stated, "What I can say, and I make this submission from the prosecution, it is abundantly clear that in making that statement, the prosecution submits the impact of this offending has been life-changing for the victim of these offences, both in private and personal terms. It is clear the prosecution submits that the extent of the shock and fear caused by this offending has been impossible to convey." She said that she felt a permanent sense of worry that she would bump into, and this is Holly Willoughby, when he was released. Now, hearing of these matters has made her think what could have happened to her if she hadn't been able to run away from him. Thankfully, as she is, it didn't turn out worse. Now, in 2018, Gavin Plumb appeared in a BBC programme where he talked about the difficulties he had faced in life as a result of his weight.
I only really go out my front door to put a bin bag in the bin just outside the flat. And that's every few days, but that's about it. It's frustrating because I'd love to just pick up a football and go down the field, and I can't.
That was Plumb speaking at a documentary a few years ago. Now, Martin, look, we heard a little bit from Plumb there, and obviously we've heard about him in court. One thing that did strike me in some of the judge's sentencing remarks was the discussion of this online community that Plumb was a part of, this messaging group that he was in on this site called Kick that allowed him to exchange depraved messages with other people, where eventually he was caught by this undercover police officer.
Yes, I thought for a moment the judge might say something about the use, the very existence of such chat rooms. Well, he did. He said. He said that it was known as a chat room. He said, but that suggests something benign. And then he went into rather paraphrasing the type of language that was used, not just by Plumb, but by others. And I mean, that was a major part of this trial, I think, that the fact that such, as the prosecutor called, highly sexualised, depraved language was used by all of those, or some of those members of that chat room who were discussing the abduction and rape, certainly, of their targets. It was Plumb who, when finally he was engaging with a man he didn't know was an undercover police officer, but he introduced the idea that it was going to be more than rape and kidnap. It was going to be the murder of Holly Willoughby. I remember talking to the police officer in charge, Greg Wood, the Detective Chief Inspector a week ago on Gavin Plumb's conviction, and I asked him about the very existence of the so-called chat rooms, particularly that one, Abduct Lovers, and he made the point that, you know, the undercover cop in America came across that chat room, found it very easily, and he said, look, it's not beyond the wit of the providers of those sorts of platforms not to see what's going on those platforms and do something to get rid of them. The judge seemed to choose not to make a big thing of that, other than to say that, you know, it's called a chat room, but it's not benign, as that name might suggest. There were some pretty awful things going on in that chat room.
It's in Brunt now. At Chelmsford Crown Court, thank you for that. And Martin, on the news that Gavin Plumb sentenced to life in prison with a minimum term of 50 years for plots to kidnap, rape and murder the television presenter Holly Willoughby. We'll get more analysis on that sentencing throughout the afternoon. Now, let me just update you on some of our other breaking news today. 26-year-old Kyle Clifford from Enfield has been arrested in connection with a triple murder in Hertfordshire on Tuesday evening. Rachel Venables is in Bushy for us and sent us this.
The 26-year-old we know was being sought by police throughout Wednesday, that manhunt ending in the Lavender Hill Cemetery in Enfield in North London, near to where Kyle Clifford is.